Good afternoon. This is Alan Gassman with my co-host Lester Perling, and we are here today, Monday, November 21st, 5 p.m., the Monday before Thanksgiving, to talk about the new Florida prescription drug laws. We want to thank all of you who are attending. We have a number of physicians. We have a number of physician office managers. We have one other lawyer. You're all welcome here, and we're going to go ahead and cover these laws in 30 minutes or less. And we're also going to tell you which law we're on, because there's 9 different laws. I'm taking you now to our first page. Make sure my pagination works. So here you are on page 2, and we're going to show you these laws. The first law is that the doctors have to follow the prescription pad rules. The second law is that the doctors have to follow the DEA requirements. The third law is the December 31st, 2011 registration requirement for controlled substance prescribing practitioners. And many physicians in Florida are going to have to register by December 31st, and we're going to talk about what it takes to know whether you need to register for that or not. The fourth law has to do with administrative code requirements that apply to all doctors and DOs in Florida, but most of you don't know about them. The fifth law is the registration requirements for doctors who dispense controlled substances and the exceptions from that. The sixth law is the new Florida prescription drug monitoring program through the Department of Health, which is very interesting. The seventh law is the registration requirements for pain management clinics. The eighth law is the burglary and theft crimes, which basically make it a little bit hazardous to not be following rules 1 through 7. And then the ninth set of rules are the crimes and penalty provisions for pharmacists, which explain to you why pharmacists are so much more careful now than they might have been just 10 or 12 weeks ago. All right, going to page 3, I'm going to now introduce my co-host, Lester Perling. Lester is an amazing healthcare lawyer. He's with the Broad & Cassell law firm in Fort Lauderdale, Florida. And Lester and one of our law clerks at our law office, Rachel Barlow, have spent a lot of time working on our outline. Lester, welcome.
Thank you, Alan.
Do you want to go ahead and take us through page 3 here with the general definitions and then also the definition of chronic non-malignant pain?
Sure. Good afternoon, everybody, or good evening. And let me apologize in advance. If you hear a dog barking, it's because I'm doing this from home, and I have an assistant who's getting a little bit rambunctious. Controlled substances are defined under both federal and Florida law, but they're set out in detail in Florida Chapter 893.03. There's 5 schedules, rather. Schedule 1 are drugs that are highly addictive and are illegal under all circumstances, like heroin, peyote, cannabis, which is under federal law, although some states allow its use for medicinal purposes. Schedule 2s and 3s are mostly what we're talking about when we're talking about pain medications. These are drugs that have some potential for abuse, but not like the Schedule 1s. Most pain meds probably fall under Schedule 2, but also 3. 4s and 5s are the ones that have a low potential for abuse and probably don't include many pain medications which typically have a higher level of potential abuse. The most important definition on the page is chronic non-malignant pain, and that relates to what we're going to talk about in a couple of minutes in terms of registration with the Department of Health. But to put the cart before the horse a little bit, when chronic non-malignant pain is used, it's talking about pain that's unrelated to cancer or rheumatoid arthritis, and then skipping B for a minute and going to C, or that lasts more than 90 days after surgery, assuming the pain is related to the surgery and not some other pain. Those are fairly straightforward. B is sort of the kicker here, which is persists beyond the usual course of the disease or the injury that's the cause of the pain. So, Alan, I'll talk a little bit more about that when we get to the registration slide, so it's a little bit more in context.
Okay, Lester, thanks very much. All right, we'll go to page 4 now. And Lester, do you want to talk through the rules that apply to all doctors concerning written prescriptions for controlled substances?
Yeah, I won't get into these in detail, but both the Board of Medicine and the Board of Osteopathic Medicine has rules. Well, let me back up. These are actually, I'm just looking at the slide here, with control of, these are actually relate to the prescription pads. As probably most of you know by now, if you're a physician, you now have to use prescription pads that are approved by the Department of Health. Physicians have always been responsible for controlling their prescription pads, and there's now a requirement that a loss or a theft of any prescription pad be reported to the Department of Health within 24 hours, or a breach of authority with regard to electronic prescribing, so something like a password. But in addition to that, it's really a good idea to file a police report. If you know that a prescription pad was stolen, or even just some pages from a prescription pad, if you're able to determine that, then I would suggest filing a police report, because if at some point those prescription blanks are used inappropriately, then you're able to document that you in fact did report the theft at the time that it occurred, and it may take a little bit of pressure off of you or off of the practitioner when the police start investigating that improper use of those prescription blanks. And then also there's some new requirements for the prescription for controlled substances. And then, as I mentioned, there's now, you've got to use an approved counterfeit-proof prescription pad from only approved vendors, and that list is on the Department of Health's website.
Okay, let me also mention for those of you attending that we have a handbook on this law, which includes not only what you're seeing on the PowerPoint, but also all the references to the PowerPoint. And we're going to send you the handbook on this law tomorrow by email, and you're welcome to share it with others. It includes a list of all of the controlled substances, class 1, 2, 3, and 4, and a lot of other information that should be very useful. The other thing I wanted to mention is when you see language in a box, like I'm pointing out to you here, that's the law that may be in the future. We had a new Senate bill that was proposed, I think just last week, and it would become effective October 1, 2012. And instead of confusing you, we've just put any information relating to what the law may be in the future in these boxes. Okay, page 5, we're going to skip through the second set of rules, and that's the DEA requirements for prescribing controlled substances. There's been no change here, but we just wanted to point out to office managers and others that you want to be following the DEA rules, of course. Okay, now, page 3, or number 3, this is the real kicker for this month and next month, and that is determining whether you as a physician need to register as a controlled substance provider. And here we go back to that same definition that Lester was talking about, and that is the question of whether you are going to be prescribing controlled substances for chronic, non-malignant pain. If you are going to provide a controlled substance for one single client, or one single patient rather, for chronic non-malignant pain, even if it's your mother-in-law, then you are going to have to register under this statute by December 31st. So the registration instructions are here for you in our handbook. Page 7. Here are the exceptions where the statute is not going to apply if all of your prescriptions are written within the exceptions of chronic non-malignant pain. In other words, if you only write prescriptions for people within 90 days of surgery, then those prescriptions won't count. If you only write prescriptions for cancer patients, those prescriptions won't count. If you're writing prescriptions for rheumatoid arthritis, that won't count. But it has to be rheumatoid arthritis. It can't be the other varieties of arthritis. If you're writing for hospice, that doesn't count. And then, of course, here's the one that Lester's going to talk more about. But if you're writing for pain treatment during the usual course of a disease or injury, that doesn't count either. So even if you are, and I'm sorry, I skipped a page there, even if you are post-surgery by more than 90 days, but you're within the usual course of a disease or injury, then you're probably exempt. So the question for this registration requirement is, are you going to write any prescription to anyone that does not meet any of these exceptions? Lester, did I get that right?
You did. A little bit more about the usual course of disease or injury. There's really nothing out there that defines that particular exception any better than what it just says. So physicians are going to have to use their clinical judgment as to whether or not they think that it's within the usual course of a disease or injury to be prescribing the pain medication. So for a couple of quick examples, if I let's say sprain my wrist and it's a severe sprain, let's assume no surgery is required, and so I get some Darvocet. I don't think they sell Darvocet anymore, Percocet. And that would be the usual course of the injury. It's immediately after the injury. However, if 3 months later I'm still asking for pain medication, arguably anyway, that's outside the usual course of the injury, and therefore would require registration. Now, on the other hand, let's say a patient has diabetic neuropathy and therefore has either constant pain or frequently recurring acute episodes of pain. Arguably, the treatment of that pain is going to be in the usual course of that illness. But again, those are going to be clinical judgments, really, that the physicians are going to, each physician is going to have to make based on the nature of his or her practice or the individual patient, and be able to defend it if the physician is not registered and is ever investigated by the Department of Health with regard to not registering. So, there needs to be some sort of literature on the subject that would support the physician's decision, or expert witnesses that would be able to support the physician's decision in that regard, because it's going to be up to the physician to prove that it is in the usual course of the illness or injury. So that's obviously a really gray area. It provides potentially a large loophole, but also provides potentially an area of abuse that could get physicians in trouble if they're trying, if the Board of Medicine ultimately determines that they're trying to stretch that exception too far. But the key point is you've got to be prepared if you're going to use that exception and not register. You've got to be prepared to defend that decision.
Okay, very good, Lester. Now, a couple of notes here at the bottom of this page. First of all, if you're prescribing Xanax or a similar medication for anxiety and not for pain, that's not going to fall under this rule. You just need to make sure that you document your chart that you're providing it for anxiety and that the patient's not in pain. Secondly, we're about to talk about some standards that are going to have to be met if you write a prescription for this type of pain. And I want to just note that the board-certified pain-related doctors are not exempt from registering under the statute. If you are a board-certified anesthesiologist, physiatrist, neurologist, or you have a board certification for surgery or in pain, a pain-related specialty, you are not exempt from this registration requirement, but you are probably exempt from the requirements on page 8, which are the patient record documentation. Now, if you are not a specialist and you are writing for non-chronic, for this type of this chronic non-malignant pain, then the new standard of practice is medical record documentation to include a lot of observations. Now, this can be done by your nurse practitioner or your PA, but it's going to have to be done. And even if you are board certified in one of these areas, you will be safest for yourself and for the patient to go ahead and follow these standards. because doubtlessly these standards will be shown to juries when there are problems in the future. Lester, anything in particular you see on this page that bears special mention?
Well, I think I just want to mention, too, agree with you, Alan, with regard to following these requirements, even if you're in one of those specialties, just because I think they are going to just become the standard of care. But as we'll see in a minute, a lot of these requirements actually already apply to any physician who prescribes controlled substances for pain in regulations that have existed for a number of years. There are a couple of things in here that are additional. Probably the most onerous of them is having a written controlled substance agreement, which I think is down there in the second group. And not that one, Alan, number one below that.
Right. Okay.
Because a lot of patients who aren't, drug abusers are not, they're taking drugs for a specific purpose or pain medication for a specific purpose, or may object to signing something like this or feel like you're treating them like a drug abuser, and it's just something that, you're going to have to explain to them. But that's probably the one that I'm hearing from most physicians they like the least. The rest of these things are probably not unreasonable, even if you're in that category of exempted physicians.
Well, and I'll take you now to page 9, and these are the exempted physicians who don't have to follow these standards from page 8, and that's the board-certified anesthesiologist, physiatrist, or neurologist. Now, notice they are probably going to expand this to psychiatrists and rheumatologists. So just so you know, if you're a psychiatrist or a rheumatologist, you're not exempt from all these requirements yet, but you may be in a year. Then on how to register, on page 10, we give you the link, and in our manual that we'll be sending you tomorrow, we also let you know all the information that you will need to have available to you when you go to the link. All right, now on page 11, this is a completely different set of requirements that most physicians are not even aware of, and this is your Florida Administrative Code. The entire code section is in the book that we're going to send you tomorrow, but if you write a prescription for a controlled substance for any pain, you have to make sure that you pay attention to the medical records requirements set forth here, and also in addition, read the other requirements in this regulation. Now, Lester, I've got one question from Cheryl White, who's a very well-respected medical consultant here in Pinellas County. She says several physicians have been charged or alleged to be over-prescribing. She asked the Board of Medicine for a definition of over-prescribing and that they could not provide a statute. Her question is, are we to assume that inspectors will use reasonable prescribing as a barometer, or what is this about?
Well, over-prescribing really is a standard of care issue, and so it falls within, there's not a specific provision in the Practice Acts that discuss over-prescribing per se. I don't recall this. There are some that dance around it, but basically it's from a Board of Medicine or osteopathic medicine perspective, it's a standard of care. And so the board has to show that, just basically prescribing the controlled substances in situations where either the patients don't have the correct indications based on the medical record documentation, or prescribing them in excess quantities, things like that. And, particularly now with the drug database we'll talk about shortly, they're going to be able to track that much better, that information. So that's basically all, in its simplest form, that's all over-prescribing is prescribing controlled substances outside the standard of care. And that's a disciplinary matter. There's related criminal matter charges that sometimes are associated, which relate to selling prescriptions or things like that. But in the normal course of a physician's practice, it would be more the standard of care type of issue.
Okay, very good. And Cheryl, thanks very much for that question and for watching us today. Now I'm going to talk just for a minute at most about the dispensing of controlled substances. The law is also really regulating what physicians can dispense drugs. And of course, a complementary package labeled as a drug sample or a complementary drug is still going to be okay. And surgical procedure medicine issuance is still going to be okay. But there's going to be obviously a lot more regulation. There's going to be a lot more scrutiny on what doctors are doing and not doing. There's going to be registration requirements that are going to be more closely reviewed by the government. So if you're dispensing or you think you want to dispense, you want to be very, very clear and careful on what you're doing to make sure that you're going to follow all the rules. Anything to add on that, Lester?
Yeah, I mean, just one point is that, dispensing practitioners, which do have to register with the Department of Health, the limitation now is particularly on the Schedule II and III drugs, which are now prohibited from being dispensed by a practitioner other than the exceptions that Alan just quickly ran through. So, that's really targeted to the pill mills that made most of their money on actually dispensing these drugs, not just the patient visit, but selling the drugs. And so the legislature just simply took away the right of any physician to dispense Schedule IIs or IIIs other than in this set of limited exceptions.
Okay. So now going to the sixth set of rules, and that is the new drug monitoring program, the eForce. Lester, I'll let you go ahead and talk about that.
This is actually something that doesn't impose any additional burdens on physicians. It does, unless they're dispensing physicians, but it now requires any pharmacy or dispensing practitioner to, of course, to register, but also to report the dispensing of any controlled substance within 7 days of its occurrence. And that's been in place now for a couple of months, and so there's already a database that's starting to form. It went live on October 18th to allow physicians to register and access, and other practitioners to register and access the database, but they were actually collecting data before that. Physicians are not at this juncture required to check it, although if you look at the note on the slide down there, the proposed legislation might change that. But for the moment, physicians are not obligated to check it. But I think that without a doubt, other than maybe a very, a one-time prescription for a few pain pills due to an acute injury, a physician would be well advised to check it with each and every patient at least once or once a year, because they may be surprised what they find. I'm already hearing from physicians where they have in fact checked it. They have found patients who they would have never known otherwise, but are doctor shopping, and they're getting prescriptions for the same or similar medication for multiple patients. By knowing that, they were able to basically not prescribe anymore and kick them out of their practice. And I think this will become another standard of care issue, that if a physician continues to prescribe to a patient who's also getting drugs from other places, and that patient is harmed, and the physician did not check the database, I think that could be an issue in a liability suit, or even a disciplinary action against the physician, because they might have prevented the adverse consequences. So I really strongly encourage physicians to use this, because I can assure you the Department of Health is going to be looking at your prescribing habits, and you don't want to be the one who's prescribing on top of a lot of other physicians prescribing.
Right, right. I think the standard of care is probably going to become that you do need to check it. And as Lester said, we've already had a handful of physician clients who have found out that the patients, believe it or not, are not telling them the truth and are obtaining the same medication from multiple sources and multiple pharmacies. So this system is already beginning to work. And the proposed legislation for next year is that physicians will be required to check the database. All right, I'm going to go ahead and get to, with 5 minutes left, we're going to talk about the registration and inspection requirements for pain clinics. Now, I know some of you who are watching here are in pain clinics and you are properly registered. But for those who aren't, you must register as a pain clinic if either of the following things are happening in your medical practice. The first one would be if you are advertising in any medium for any type of pain management services. So if you have the word pain on your website, in your advertising, in the name of your practice, then guess what? You're a pain clinic, and you're going to have to register, and you're going to have to follow these myriad of rules that we're going to briefly refer to here. Alternatively, if in any month the majority of patients are receiving these medications for chronic non-malignant pain, then you are a pain clinic, and you have to register. And if you have multiple locations, each of your locations has to register separately. Now, they are obviously going to try to keep non-physicians who are not with publicly traded companies from opening new pain clinics. The registration can be denied by the Department of Health if a clinic is not 100% owned by a licensed physician or a group of licensed physicians. Oops, sorry about that. Now, the exceptions to the registration requirement do apply for a clinic wholly owned and operated by one or more board-certified anesthesiologists, physiatrists, or neurologists. Now, please note that that's wholly owned and operated. So it can't be owned by a spouse who's not a board-certified anesthesiologist, or one of the doctors who's not a board-certified anesthesiologist, physiatrist, or neurologist. They may add psychiatrists and rheumatologists to this exception next year, but as of now, there is no exemption for psychiatrists or rheumatologists. There is an exemption for wholly owned and operated by board-certified pain doctors. And of course, there's exemptions for hospitals and ASCs and publicly held companies and medical schools, clinics that don't prescribe any controlled substances for pain, or the tax-exempt entities. Also, you have exemptions under page 26, or, I'm sorry, on page 25, well, where was I? It is page 26. I'll go to page 26 now at least. If you are a pain management clinic, you have to have a designated physician responsible for complying with dozens of requirements. The designated physician has to be a medical doctor or an osteopath with full, active, unencumbered license who practices in the clinic. And if you're working in a pain clinic, you have a duty to make sure that there is a proper designated physician actually doing the right things in that clinic. And there's a lot of things that that person is responsible for doing, including making sure that the bathroom works. So you're talking about a lot of responsibility if you're running a pain clinic. Lester, what would you add to this?
I think the one thing, a couple things. One is getting back to the definition, the advertising issue. That could catch a lot of people, because if just even on your website you mention that you treat headache pain, and that's the only time you ever mention the word pain, that, according to the Board of Medicine, is enough to require you to register. So there's probably a lot of counterintuitive situations. You say, well, I'm not a pain clinic, that's not what I do. But on the other hand, you just use the use of that word on a website or in a brochure could pull you into the definition. And then the other point is really to emphasize what Alan's saying about the designated physician. I think if I'm a physician and I'm working in a pain clinic and they ask me to be the designated physician, I think long and hard, unless I truly have control over all those things. Because if something goes wrong, I think that the Department of Health is going to come down hard on the designated physician, because they want a person who they can slap around in those circumstances, and that's going to be the person. So unless you can actually make someone fix the bathroom, for example, as Alan points out, you don't want to be in that role, because if the administrator, let's say, or the manager of the clinic says, we don't have the money to fix the bathroom, you're stuck. So there's a lot of considerations before agreeing to become a designated physician.
Okay, well, Lester, that completes our 30 minutes. I'll point out that we do have a Section 8 of the PowerPoint talking about the crimes that apply. We have a section 9 in the PowerPoint showing you what pharmacists are having to comply with and why they're harder than ever to work with for good reason. And then a section 10, we have a memo from Dr. Singh of Access Healthcare, who is co-writing this handbook with us on how he implemented these rules in his office. And also we have Dr. Singh's protocols. These are all in the PowerPoint. Please feel free to ask for extra copies of the PowerPoint, forward the PowerPoint. Tomorrow we'll be sending you the handbook. We welcome any and all of your questions and comments. And Lester, do you have any final words for us?
I think we've covered what we can in the 30 minutes we've allotted. So.
My hat is off to all physicians and all physician managers for everything you're doing because of this new problem. A lot of practices are sending the pain work out, but a few practices are embracing it and making a good dollar, doing it right, and doing what's right for patients. So have a great evening and a fantastic Thanksgiving, and thanks again for your participation.